Good morning.
Good morning.
Good morning. I believe this is everyone, so I think we're good to get started. Good morning. Today is Wednesday, April 9th, 2025. The time is 9:31 a.m. And this is a pre-hearing conference, the matter of William Castro before the Massachusetts Peace Officer Standards and Training Commission. This pre-hearing conference is open to the public. We are convening remotely over Zoom, and this pre-hearing is being recorded. The Honorable Kenneth J. Fishman is the presiding officer over today's pre-hearing conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission, and this matter is now before Judge Fishman.
Good morning, Counsel, and good morning, Mr. Castro.
Morning, Your Honor.
If Counsel would simply
morning, Your Honor.
state their appearance for the record.
Sure. Timothy Hartnett, Enforcement Counsel on behalf of the Division of Police Standards.
Walter Jacobs on behalf of William Castro. Good morning, Your Honor.
Good morning. All right, so we're here for a pre-hearing conference. It's our first meeting on this particular matter. It seems that there are several issues, some of which are, let's say, I don't want to say out of the ordinary, but ones we haven't confronted before. So we'll need to sort of talk about how to proceed with those. Thank you for your pre-hearing memoranda. And just let me ask you this. So I understand that the first question is whether there's any possibility or progress with regard to resolution. I think both the parties indicated that there are no discussions ongoing. Is that correct?
Not been to date, Your Honor. I'm not opposed to talking with Mr. Hartnett. I've communicated with him on other issues, and I've communicated with him on various things during the case. And we did have a meeting with Mr. Castro and Mr. Hartnett and others at Post in Boston. So I've spoken with him, and we have had meetings. We've submitted significant amount of documents to the Post. One in December, and then as part of my show cause response. So I'm not opposed at all working or talking with him.
Mr. Hartnett, do you think that would be?
I'm happy to discuss. I think, but I'm being candid though. I don't see this as a case that's realistically going to be resolved, given the response and given the seriousness. That said, I'm always happy to discuss.
Okay.
I'm happy to discuss those options.
Well, okay. You're just. I'm sorry. Your audio is a little bit muffled, but that could be my ears.
No, it's probably me. Is it a little better now? I don't know.
Lizzie, are you having the same issue?
Yeah, you sound a little bit like far away from the mic.
There's a little echo.
I don't know where the mic is on this thing. Is that better?
Actually, it is.
Yeah, it sounds better.
Maybe
Okay.
we're
I think it's
imagining
on the side
things.
of my laptop and it was pointed the other direction. So
okay.
Okay, so
you're in charge of all electronic work, I see.
that's right.
In any event, I think we all heard your point, and even if, of course, even if you're not particularly optimistic about an avenue for resolution, I would encourage you folks to talk to see if there are any viable approaches to resolution. Otherwise, we're certainly prepared to move forward with this. And let's talk about just following the course of the pre-hearing order, the discovery issues. So it's an interesting case for discovery. There's fair amount of witnesses that are listed by the parties. Mr. Jacobs, you indicated that you anticipate the need to subpoena witnesses. But I don't know that there has been, and I think I read that you haven't made any formal discovery requests of the division at this point?
We had spoken at one of the meetings that we went to about getting the materials that have been sent to Post and communications between the LPD and Post, and Mr. Hartnett, I believe, as I recall, indicated that that was not the time. So my assumption is that this hearing is the time to discuss the procedure of getting those materials, whether we need to make a formal discovery request of the division or whether we have to issue subpoenas to the division. I'm not sure exactly how Your Honor wants us to go forward, but we will proceed in whatever way you deem appropriate.
Well, there's this is a pretty open discovery process in my experience so far, and I think that and Mr. Hartnett, please correct me if I'm wrong, but I would anticipate that you would just need a formal request for discovery and respond to that.
Sure. Just generally speaking, the rules about discovery can be found in 801 CMR 1.01, Section 8. Those are the general rules of discovery and adjudicatory proceedings, and they apply here pursuant to a clause within our own regulations. That said, one of the things it says is that parties should engage in voluntary discovery, and we certainly would do that here, and we've done it before. It can be formal, it can be informal, it can just be an email asking for certain things. I'm happy with that. You know, but just in terms of document requests, the rules say we get 30 days, and it would probably need those 30 days if there's a request. And if I need more than that, I would come to you, or we'd come to some agreement amongst the parties. But yeah, I would need some sort of formal request, and that's under the rules that starts after the issuance of the order to show cause. So that's why it can happen now.
Yeah.
So
So you'll follow through on that, Mr. Jacobs?
I will, Your Honor.
Okay.
and I'm happy to talk with Attorney Jacobs offline about that procedure as well,
okay.
if we want. Since we're on that topic, given that, I'll just jump ahead a little bit here. I mean, maybe I'm jumping ahead. My thought on that was that we're going to need at least another 45 to 60 days before we decide really next steps. We can continue to talk about other issues, but I'm thinking we're probably going to need a status conference and rather than picking other dates.
No, you're absolutely right. I mean, I anticipate, just from what I've read, and I've seen the volume of material that's been exchanged between the parties and the complexity of some of the issues, I want to make sure you have adequate time to exchange information and documentation. And we'll set up a schedule after we get done here, because there's a lot of issues that affect that scheduling that I think have been raised here. But I know you two will communicate and do your best to exchange discovery. With regard ultimately to the issuance of subpoenas, if there are third-party sources, for instance, that you need to obtain information from that are not in the possession of either party in terms of a discovery exchange, first of all, I would urge you to make those requests without the necessity of a subpoena. If you run up against issues where parties are unwilling to provide the requested information, then you should request issuance of subpoenas. To the extent that you need them before a hearing, an evidentiary hearing, I don't know, but you'll obviously, if you confront them, I understand that we have the power to issue subpoenas, and we'll do so if necessary. Has that been an issue in the past, Mr. Hartnett?
No, not for me. I mean, I think other parties have, in other cases, have issued subpoenas and whatnot, and we've issued them. I mean, I've issued them in the middle of a hearing, actually, but
All right.
and there've been some pre-hearing, yeah. So it's not an issue. The only thing I would flag here, just to note for everybody, is that, you know, we are talking about third-party witnesses here, so there may be an issue of having to give them notice of any sort of subpoena as well. You know, if we're subpoenaing records about a third party, not from a third party, but like sensitive medical information about a third party, I would just note that probably should, the interested party should be given notice. I think they have a right to object to that subpoena as well, if they choose to. I'm not suggesting they will.
Well, as in any proceeding, I suspect that they could move to quash subpoenas if they implicate privacy matters or other privileged communications, but we'll deal with that as it goes along. But that's why I say I should, in all instances, I urge you to communicate with the prospective witness or document provider in advance of seeking an issuance of a subpoena, A, to see if they'll do it cooperatively, and B, so we can determine, as Mr. Hartnett suggests, whether they're any objections to it that are based on confidentiality issues or privacy issues or anything else. Attorney-client issues, who knows? But the other thing I urge you to do with regard to all of that, since there may be these issues could arise perhaps in the context of these proceedings more than in the other proceedings, is don't wait until we have a status conference down the line. If you run into these issues, just need to get answers from me or from staff here, just go ahead and contact us so we can be working on those issues as we go along. What we're litigating becomes a more interesting issue perhaps here, because several issues have been raised by the respondent that quite frankly, I'm interested to get the parties' view on how they ought to be approached. Starting with the fact that I know there was an objection to the suspension order, excuse me, in the absence of a hearing in which the respondent participated prior to the issuance of the suspension hearing. There was a hearing, but the respondent didn't participate for whatever reason. As you know, Chair Hinkle has issued an order assigning me to deal with that issue, which makes sense since I'm dealing with the overall case. But it's the when and the how, particularly as to that issue, that I wouldn't say it's vexing, but it's an interesting issue. As a practical matter, if at this stage of the proceedings, I was to find that you should have had an opportunity beyond the notice that you got to have a suspension hearing, and that one needs to be conducted even at this point in the litigation. I mean, that's sort of the first question. And if it does, whether it's a separate hearing that needs to be conducted before the final hearing in this matter, and how we would proceed with that. There's a lot of questions that even revolve around that. For instance, would the record be limited to what was in the stage of the evidence at the time that the original suspension hearing happened? Much the same way that perhaps when there's a challenge to in a criminal proceeding to an indictment having been issued, you're talking about what was in place at the time the presentation was made. So there's subsidiary issues that I've been thinking about. But I really, other than I think the division's comment that many of the sort of issues like that may be viewed by the division as irrelevant. But what's your position about the suspension hearing? Now we have an order from the commission in that regard to deal with it.
If I could, Your Honor.
Yes.
So there's two, when someone's trying to lift a suspension, there's two tracks. There's two different ways that can be handled. One is you can seek a single commissioner review, and that review is just as to the issuance of it and whether or not it was properly issued. And then there's a separate track, which is at any point, and that's limited in time. You have to assert that at a certain within a certain amount of time, and then there would be a hearing before a single commissioner for that. Then there's a different track, which is you can ask. So presumptively, once a suspension goes in, it is presumptively stays in place until it is revoked. So what that means is there's another process where it could be revoked by the commission. So the other process is that you can ask the commission as a whole to revoke it for whatever grounds you think are appropriate. But that, when you review that, you're looking at everything, right? It's not just that. It's not just the issuance. So my reading of the order that came out on April 4th was that the commission found that as to the first track, that's over. really we're not going that way because there was a process. He needed to comply, requested in a certain way, and then the commission has determined that that sort of avenue is closed now. And so what we're left with is now a question of whether or not it should be revoked, which is the broader issue, which is not about just the issuance, but whether or not it should be revoked at all. And that I don't know how you want to handle that. That can be in a separate hearing, or that could be at the conclusion of the evidence. I don't know what, it's unusual. That's it could also go directly. I mean, the commission has decided to have you gather evidence on that rather than having it go directly to the commission. I think given the complexity of it, I don't know. But that's my reading of the order.
In the order that you're referring to, the April 4th order, I understand your position about the first track, but with regard to what I was appointed to do is to preside over the judicatory hearing as they relate to the challenge of the suspension order. And there's citation, I just don't have the CMR open before me, but do you have that in front of you, Mr. Hartnett?
Sure.
I'm just asking if there's citation to the provision with regard to the revocation of the suspension order that's contained in the order. And
I don't have I can pull up the order. I don't have the order in front of me, but I do have the CMRs.
right.
With me 1 sec now. I will pull it up.
Judge Fishman, so you're requesting the provision in the regulations that allow the respondent to challenge the suspension? Is that what you're asking for?
More or less, but to do it at a point where it's not the single commission review that commissioner review that to which Mr. Hartnett was referring, but rather this request essentially to revoke the suspension at any time in the proceedings.
Yeah. So the single commissioner review of a suspension is in 555 CMR 1.09. And to go before the full commission, which at the time we cited 555 CMR 1.06, a suspension can't be revoked until a final decision is rendered by the commission, by the full commission.
And that's under 1.06, you're saying?
Yes. And final decisions are covered under 555 CMR 1.10.
Right. Okay.
So 1.06 section 3 says any suspension issued by the commission under 550 under that section shall continue in effect until the suspension of issuance of the final decision of the commission or until the suspension is revoked by the commission. So people have in the past that we've just created it's a presumptive that there's a procedure that you can just ask the commission to revoke it. And there's no time that doesn't talk about a time frame. So people have done that in the past. They've asked to lift it, but that's a request to the full commission.
Particularly where that's written in a disjunctive, sounds like that's an alternative approach.
Yeah. I mean, it doesn't say that there's a process. I think we've allowed that process. And I think we talk about it sometimes when we issue guidance on the suspensions and stuff. We tell people it's an option.
We did, Your Honor, exercise, my apologies, Your Honor. We did exercise what we believe to be our right under the CMR to request a hearing to lift the suspension. And I do not believe that that has directly been responded to by the commission. We asked for that to be done because we believe that the letter of order of suspension is based on false information. It was based on a variety of things. One of the things which does not appear any longer in the show cause order, but was in the order of suspension, alleging that Mr. Castro is liable for some hiring, firing, and certifying misconduct. Mr. Castro is not the appointing authority. He does not hire or fire, and he is not the certifying authority. That is the Post Commission. So that basis for the order of suspension, the summary order of suspension without any hearing, is false. Another basis for that was the fact that there had been no investigation of the car pursuit. Yet that is also false, because the mayor did conduct an investigation. A report was compiled. There were documents related to that. The mayor ordered that submitted to Post, and we brought that up in our pre-hearings with the Post staff, that was false, and we produced all the documents in a voluminous set of materials showing that that information was false. And then another part of the summary order was the car pursuit, alleging that Mr. Castro had violated a pursuit policy he had never seen or signed off on. We produced that documentation. That was part of the mayor's investigation. And then the fourth one, that as I recall, and I don't have that letter in front of me, was that Mr. Castro had lied in his report of the incident, and we're prepared to vigorously defend that allegation and tainting of his reputation and integrity, that there was no lie in his report. We'll go over his report line by line, and we requested a hearing to lift the summary suspension because there was no reasonable basis to summarily suspend someone who was also in the running for the future police chief. His career has been irreparably destroyed by this summary suspension without a hearing. So we requested a hearing to lift it, and have been ignored as far as I can recall. There's been no response. We received the show cause to go forward on all the issues, but not the opportunity for a hearing, which I believe the CMR allows us to have the suspension lifted. We're going into the full hearing suspended on a presumption of guilt when we've asked for a hearing to have that suspension lifted. And I think we have a right to that hearing based on the issues in the summary letter of suspension. Now, if Post were to believe that there was not a basis, they should then lift the suspension. If they feel there's something that happened subsequently, then I suppose they can issue a subsequent order of suspension against him, and we'll defend at the final adjudicatory hearing. But we I think, have a right to a hearing to lift the suspension based on the order issued in the summary suspension.
If
So-
I could respond briefly.
Yes, go ahead.
So based on the order that was issued, now let's just be very clear. I am not the clerk's office. I am not the hearing administrator. I'm not the commission itself. I represent the Division of Standards. So I'm not necessarily a party to what's to the out of these conversations, but according to the order that was issued, so what happened was that Mr. Castro sent an email saying he wanted to have his suspension lifted, and then there were but it did not comply with the requirements as to like what you had to specifically request, and didn't clarify. And then there was several attempts made both to him personally and to his attorney at the time. He had a different attorney at the time. His attorney at the time, there were several attempts made, and then the commission, and then nothing was heard, and so he never had a hearing. That's why, according to the order, that's why no hearing was held back in last of April. I'm not a party to that. I'm just saying what's in the order. That's a finding that's the commission has already issued. So I don't believe that's before you. I believe they've already issued that decision on that track. Of course, if we go down there, I'll just note that I definitely disagree with a lot of the characterizations of the evidence that was just presented, but I don't think we're even there, or that we need to go there, because there's an order from the commission that says that avenue is now closed. So, but if we do want to have a separate, if we're looking to, look at not just the issuance, but whether or not it's just, the question is really, you have to kind of piece it together from the regulations, because it doesn't say what the question is, but it just says it can be revoked. So it's whatever the commission would deem appropriate to revoke a suspension at this point. Candidly, I don't see how that would be at all appropriate. I mean, the commission has already found that there was sufficient evidence to move this forward to an adjudicatory proceeding. So I can't imagine that seems like quite a high hurdle to then suggest that the same commission should feel like the suspension should be revoked. And keep in mind that the question for the revocation, for the suspension does not require that the standard for that suspension, which was issued during the pendency of the preliminary inquiry. The standard is whether or not, by a preponderance of evidence, it would be in the best interest of the health, safety, and welfare of the public. It does not require proving of specific allegations or anything like that. It does not require clear and convincing evidence. It is a different question for the suspension. And so a question, a standard that I think objectively is even harder for the respondent to get over, but I'm happy to have that argument at some other hearing if we need to, or we can, but I don't know, how much evidence he would want to put in at that point, or what the schedule would be for that. But
Well, that would be my next question, Mr. Jacobs. Regardless, so it's, in a sense, it's a little bit of a rose by any other name. If we're proceeding under a request to revoke a suspension with the range of issues that you've identified as a basis for doing that, are we, in essence, duplicating and even going beyond what we might do in a final hearing?
No, Your Honor, I think we would be going short of what a final hearing would have. I am successor counsel. Mr. Hartnett is correct. Mr. Castro is represented by prior counsel, but my understanding, and I could be wrong because I was not part of the case at that point in time, is that the two prongs for lifting the suspension, that the issue addressed by prior counsel was the first prong, which has a somewhat of a time limit on it, and that Mr. Castro, his prior counsel, was not going forward under that prong. The other prong request, and that is for a single commissioner. The other prong is to go before the full commission. I believe we have that right. I put in a specific, discrete, separate request to go before the full commission to have the suspension lifted. That is, and I think from due process standpoint, Mr. Castro was entitled to a hearing on that request, separate from the issues that would be adjudicated in the final hearing. Now, I don't deny that some of the issues that were put forward in the initial summary suspension do not appear, to my recollection, in the final show cause. I think the enforcement council, or whichever arm of post is proceeding, has decided not to bring forward issues of hiring, firing, and certifying and bring those allegations forward. They were in the initial suspension. They are bringing forward allegations of the improper car pursuit and an allegation of falsifying the police report. Those things, I think certainly, and the question, I believe, of the mayor, whether an investigation was done. We have the written documents. We provided them to post. I believe that we could, on a preponderance of the evidence standard, be able to overturn that initial summary suspension. I think we could have done that a while ago when we requested the due process right to have that suspension lifted. And the commission, the various arms of post, whichever arm is the one that's supposed to respond, and I'm not saying that that is directly Mr. Hartnett, because it may not be, has ignored, as far as I can recall, any opportunity for our due process to have the suspension lifted. But not all the things that would go to the final adjudicatory hearing would be part of that hearing, because they were not raised in the order of suspension. We would be arguing the initial summary suspension, where Mr. Castro was suspended on this allegation that he's a threat to the health, safety, and welfare of the public, when we don't believe he was doing anything other than his sworn obligation as a law enforcement officer. And we believe in
which form did you make the request that you're referring to? The original request for.
I believe it was sent to
Go ahead.
I believe I sent an email. I think there was an attachment letter to various individuals. I'd have to go back into my files at post requesting the suspension, a hearing to have the suspension lifted. I would have to go back into the files. I'm in a courtroom right now waiting another hearing. But I can get those and forward them to you without any problem.
So let's do that. I want to make sure that the record that's relevant to this issue is before me in a designated way. And Mr. Hartnett, I know what you said, and I've followed what you said as well, but I do want you to submit a response in writing with regard to the entitlement to the kind of hearing that, unless it's your opinion that you don't have a position.
Well, no, if he's just asking for a hearing on the second track,
Yes.
I think that's he does have that. He does have that. He does have that right. He can ask for that hearing, and I think that's why I think they're asking you to take the first look at that and then advise them on that.
Well, that's the way I've been reading it too, and that's why I say rose by any other name. I think that if we have a hearing that relates to the so-called second track, doesn't that accomplish your goals as well, Mr. Jacobs, in terms of a due process request?
Yes, it would. Yes, it would, Your Honor.
Okay. So,
and I'm not opposed. I'm sorry, I don't mean to interrupt you.
No, you're
I'm
right.
not opposed to submitting that information to Your Honor and then having another hearing by Zoom where we can, after you've had a chance to review that material, where we can further discuss that so we can make a productive discussion so we can get this whole process moving forward.
So,
right, so-
Your Honor,
Yeah, go ahead.
I just want to clarify, I think things that might be getting a little conflated here. I mean, look, when you're asking to revoke it, you can certainly argue about the initial issuance, but I just want to make clear that what you would be considering, what the commission would be considering, is all of the evidence to date, not just whether or not it was properly issued. In fact, if it was not properly issued, is really kind of irrelevant to the question of whether or not it should be revoked now.
I mean, because there are other factors in play, more
other
evidence
factors in play. And in particular, one thing, and a reason why I raised this too, is that there would be, the commission has information that it receives in the form of a preliminary inquiry, which is confidential. However, you would need to see that in order to be able to advise them. But you'd have to take that in camera because it's confidential. It's both confidential under the statute, and we would also probably take the position that it's attorney-client privilege, since we're attorneys giving a recommendation. But more importantly, it is clearly confidential under the statute, the preliminary inquiry report. And so you'd have to view that in camera, I think, in order to advise the commission. Because I would be arguing, I couldn't really talk about it, but I mean, my argument would probably be, given the information that's in there, revocation does not make sense.
So how does, from a due process perspective, how does a party, a respondent, have an opportunity to reply to the allegations or the evidence that it's not entitled to see?
I don't have a good answer for that. I do, but it's confidential under the statute. So, and the question, I don't know. Because the problem is, it is the statute is very clear that it's confidential. Right. Like, it has no exceptions. It doesn't say anything. But that is also information that the commission has, and it's information that the commission would have to consider when it's deciding whether or not to revoke something. So, I think the way it's viewed is that he can argue whatever he wants for why it should be revoked for whatever reasons. And, he knows generally what the he's got an order to show cause. He knows what the allegations are. So, he can argue that all of them that there's no merit to any of them, I guess, and that's how he can argue it. But he doesn't, he doesn't need to see the recommendation as to whether or not to move forward to an adjudicatory proceeding, which is what a preliminary inquiry report is.
So,
If the commission, my apologies, Your Honor.
no, go ahead. Go ahead.
I think from a due process right, it is very important to Mr. Castro that he preserve his due process rights. And I believe from a procedural standpoint that he would be asking the commission to lift their summary order of suspension, which was done in March of 24, based upon the documents and the information recorded in that summary order of suspension. That is what is the basis of the suspension. That is the only basis of the suspension, would be our argument. If they want to issue another order of suspension, that's perhaps up to the post to decide if they want to do. But I think from a due process standpoint, we would be arguing the only thing we have to argue and prevail on is the document that was submitted, the summary order of suspension. Now, Mr. Hartnett may be correct in part that counsel's communications have a certain degree of privilege, but if allegations are being made against Mr. Castro and the commissioners are going to be the adjudicatory body, I believe Mr. Castro has the right to know what is being alleged, because the summary order of suspension, I can assure you, I have the documentation. It is blatantly contains false information. It contains lies in that document. I am not equivocating. I'm an officer of the court. I have the documents to prove that without any question. So if the enforcement counsel is going to argue he has a right to submit things to the commissioners that might also, and I'm not casting aspersions on him personally, but if the document might contain things, I think they should be making their decision based not on a document that was created previously. They should be basing their decision on evidence put before the commission that all sides have the right to see. We've given 7-inch binders to post-commission. We have provided documentation. They want to go forward. Fine, they have that right. We have the right to defend, and we have the right to know.
But your 7-inch binder goes well beyond the limited issues that you defined a few minutes ago relating to the initial suspension order.
That is correct.
It relates to the whole panoply of allegations contained in the order to show cause. So and so that raises the question. When I initially looked at this, I said it has the feeling that at this stage of the proceedings, that ultimately the question has been broader. I mean, what if as you said, I mean, think of the practical part of this, that if we had some kind of limited hearing that strictly addresses the issues of what was in the hands of the party and the knowledge of the commission at the time of the issuance of the initial order of suspension, whether I even have the right to do that, I'm going to relook at the Chair Hinkle's order with that regard. But if that's it, then, but at the time that it's being considered, it's determined that there's a lot more evidence that may be relevant to the question of whether Mr. Castro should be suspended while this proceeding is ongoing. Aren't we, as a practical matter, really looking at adjudicating the whole case twice?
Oh, we would only be adjudicating the content and the basis of the summary order of suspension letter. That's all we would be adjudicating.
If that's the case, and the commission said, well, that's fine, but now we know this much, and that's all relevant to whether he should currently be suspended, and you are looking to address that because all of a sudden the issue has become broader than the initial decision, presumably you'd be trying to have a hearing that relates to suspension with all the facts that are now alleged, prior to having a final hearing at which the very same evidence would be considered.
I think it's a question of due process, Your Honor, with due respect. Mr. Castro is no longer employed by the Lawrencetown Police Department. He is serving as chief of staff to the mayor. So what happens to his law enforcement position? He has no employer for law enforcement at this moment in time. So he is not going to have a badge to put back on for any entity because he is no longer with the Lawrence Police Department. His position had been temporary, and he is now acting back in his position as chief of staff to the mayor. So from a procedural standpoint and a due process standpoint, if we argue the inappropriateness of the summary order of suspension and we prevail, that suspension is lifted. It doesn't return Mr. Castro to law enforcement because he's not employed by any law enforcement agency. I think there could be a discussion whether he would agree during the pendency of the hearing not to act in any law enforcement capacity or seek any law enforcement capacity position during the pendency of the hearing is something that would be open to discussion with enforcement counsel. Mr. Castro is not working in that capacity, has not been. There are allegations subsequent that he violated the suspension by acting in that capacity. What Your Honor may not realize right now, but will become apparent during the hearing, there's a lot of vendetta in the Lawrence Police Department against Mr. Castro for very clear reasons. And there have been allegations made that are just not true, and we will prevail at a hearing on the evidence and on the testimony before Your Honor.
And I have
certainly
looked at those because they're in large measure, I'm sure, contained in your detailed response to the order to show cause. So I understand that you've raised those issues.
But
question is, so
it would,
I guess the same question evolves. Can you imagine that if we're talking about the order of suspension, that needs to be considered as well?
I think the order of suspension is a separate issue that needs to be addressed in fairness and due process because Mr. Castro has requested it under this.
I understand what due process is. I appreciate your emphasizing that, but believe me, I understand what due process is. What I'm trying to do is talk about the actual process by which we afford due process and the evidence that you would anticipate needing to be presented if you were it was deemed that there needs to be an evidentiary hearing on your, let's call it your pending motion, just for lack of a better description, with regard to revoking the original order of suspension. What do you envision would be the breadth and nature of the evidence that you'd have to present? And you've listed sort of 4 issues. So
I would take the 4 square corners of the summary order of suspension, and I would refute each and every one of the allegations in the summary order of suspension so that Mr. Castro then, when he goes into his final adjudicatory hearing, he would not be under suspension because I fully believe he will prevail that there was no basis or justification to issue that order. It was improperly issued on basis of false information. But I think he has that right to go forward, but it would not be the final adjudicatory hearing, and it might even simplify the final hearing because if he is able to convince the commission on those 4 elements, then the commission would only be having to decide whether they're going forward on the remaining elements.
all right, so the 4 corners are that there's information engaged in a motor vehicle pursuit in violation of the policies of the department, that he was unfaithful in the subsequent written report regarding that pursuit, and that he or his appointing authority or failed to independently investigate whether there was a policy violation or a report, and that a question of whether respondents' hiring and certification practices containing certain candidates for employment as law enforcement officers for the Lawrence Police Department. And that's the 4 corners you're talking about.
That is all that I would be presenting evidence on, Your Honor, correct. And I believe that we will prevail on all 4 of those at an adjudicatory hearing, and the commission will be compelled, based on the evidence before it, to lift the order of suspension. I would have no objection.
So that brings to mind Mr. Hartnett's argument that in a way, as to that kind of review that you're seeking has already been addressed in the order appointing me to resolve these issues. And if that's so I'm going to decide that, okay, because that'll dictate which way we proceed and preserve your rights as well, your client's rights. But it would be helpful to have the submission again that you say relates distinctly to the challenge to the order of suspension. If you could just, I know you've provided that in the past, but if you could make sure it's sent to me again, I'd appreciate that.
I did not send it to you, Your Honor, but yes, I will send it
No,
to you
I
and
know
to
it.
Mr.
I know,
Hartnett.
and I'm sure somewhere in the process it found its way to me, but I don't have it clearly in mind right now. So if you could send it to our staff, and I'll get it directly then.
When I get back to my office later today, Your Honor, I will definitely do that. I have hearings not only this morning, but this afternoon, but I will do that this evening. No problem.
Well,
Thank
you're
you,
a
Your Honor.
popular guy. What can I say? And the question with regard to that, is there any written submission, Mr. Hartnett, that you feel you need to make at this point? Because I understand what you have said, and I'm going to slowly take into account your arguments that you've made here today, but I want to give you a chance to respond in writing if you think you need to. Otherwise, I'll analyze this and issue an order with regard to how we proceed from this point forward.
No, I don't think there's a need to respond in writing, Your Honor. I think you're correct on all those points. The one thing I would note, just because due process was brought up, and I just want to note that there is, and just to clarify something I said earlier, under the regulation, that first track establishes certain due process rights. It talks about his right to do those things. The second track is not a due process issue, because it doesn't talk about, the regulations don't talk about being able to revoke the suspension at any time. It's a procedure that we've sort of just said, hey, if you want to, we'll consider your request.
Do you think that,
but I don't think he's entitled to a hearing per se because of that.
Well, except that I'm being told that I should preside over adjudicatory proceedings, well, as they relate to it, doesn't talk about a hearing specifically.
Yeah,
Don't
I think you're correct.
Don't you think implicit in matters like that, without an articulation of a specific due process approach, that due process is implicated?
I mean, he had a due process right to challenge it earlier on, and then yes, if he makes a request, I don't know the answer as to what.
I mean, it's simple as this: if somebody comes in, forget about this is Mr. Castro, but in any instance, somebody approaches the second track in which you say there's not specific, and I have no reason to doubt you, by the way, that there's no specific reference to the process, if you will, that makes a request, and it's determined that it's a question that raises an issue that requires an evidentiary hearing and a decision by the commission ultimately. That, I guess my question is, once that's deemed to be necessary, why wouldn't that implicate due process rights at that point? Oops. You know what? Don't they always say in courtrooms you turn off your phone? I mean, really. But
No, I don't know the answer. I don't.
Well, neither do I.
He would obviously have some sort of due process, right? But what it would be and what the scope of it would be and whether or not entitled to a hearing, those are very different questions that I don't even know the answer to. I'm just pointing out that there is nothing in the regulations that talks about it. And so
Okay.
I don't want there to be a presumption that we have that has to be done. I also want to, it also, I think to your point that, if what we're talking about is ultimately something that was for the first track, well, then there's no point to having a second track hearing, because if a second track hearing is something that I think would require, it would be analyzing a lot of the same information. And so, how that gets handled, I don't know. I mean, but
Well, that's why they appoint us. I'll have to figure that out, won't I? But as a practical, no, and I'm asking the same question that you're articulating. So it's an interesting issue. So we're going to start by getting the material once Mr. Jacobs has an opportunity to send it to me. And I'm going to take a closer look at the regs, and we'll see how we're going to proceed, but I want the overall process to keep marching forward now. I don't want this to be viewed as a reason to delay the ultimate resolution of this case. So let's start by at least setting a discovery time period. And do you have a problem, Mr. Jacobs, particularly since these other issues may have to be addressed in the interim, but with a 60-day discovery period as suggested by division?
I certainly think the division will probably need that time. It may very well need more time. I will very diligently get out to Mr. Hartnett. We've been able to communicate on many issues. He's very responsive. My discovery requests, I'll probably make them somewhat formal, and then he and I can have a discussion on them. And I think we can work cooperatively together to try and resolve that. And if there's more time needed, I'm not opposed to that.
Okay, so why don't we do that? Let's set a status conference for 60 days forward from here. And if the parties agree that you're going to need additional time before it would be useful to have the status conference, just let us know and we'll adjust that schedule. Does that work for you, Mr. Hartnett?
Yes, that's fine.
Okay. So, oops, I just lost you. There you are. Liz, you want to throw a date out there for us?
Yeah, so I'm just looking at the calendar, and 60 days from now will take us to the week of June 9th. And this status conference would be conducted remotely, correct?
Yes. But by the
Okay.
way, June 9th, just see. That just falls. I've got some things that are going to preclude me from participating the 9th. So it really would have to be, let's see this. As a practical matter, sort of the end of the week of the 16th or the following week.
Okay, June 19th is a holiday, so the office will be closed that day. So we could either do earlier in the week of the 16th, or early the following week on the 23rd of
The
June.
23rd, does 23rd work for everybody?
Yes, Your Honor.
Just double checking, Your Honor.
That's fine.
I think I'm pretty sure that's fine.
So you have to go to your computer. We old timers still use these little books right here.
The 23rd is fine.
Okay.
And at 9:30?
23rd is fine. 23rd is fine for me.
Yeah,
as well.
9:30
June.
by Zoom.
You'll send the Zoom link, Mr. Hartnett?
I will send it. You'll
I'm
receive it
sorry.
from me.
We will.
Thank you. Thank you.
And in the interim, you can expect that you'll hear from me by way of order, or if necessary, an order, whether it requires more information or whether it addresses directly the ultimate process by which I think we need to proceed to address the challenge to the summary suspension. You'll do that, and then we can sort of schedule things as relates to that. But I'm not sure yet what I'm scheduling, so that's why I want to have a closer look at the material and give it an opportunity to have a little bit of thought about that as well. Are there any other issues relating to the preliminary hearing which you think we ought to resolve today? I know there was some issue, I think, raised in here about, I guess there are other issues that have been raised in the respondents' memorandum that the division has said are irrelevant. And the question is how we want to address those.
I think we possibly could address those at the next status hearing, Your Honor. When we have a little better idea of where we're proceeding as far as whether we're having, whether Your Honor decides that we're having a hearing on the lifting of the summary suspension or not, then we can go forward at that time if Your Honor wishes.
So the question is whether there's a process, if necessary, that where challenges are made essentially to, I was thinking about questions that relate to alleged violation of procedures by post. There's sort of challenges to post conduct as opposed to challenges related to the allegations against Mr. Castro. Whether those are sort of challenges that need to be addressed outside of the final hearing and before the final hearing, as they may ultimately implicate what evidence is presented at the final hearing, and perhaps, as you look at these generally, impact whether it's necessary to have a final hearing or whether there was something that happened in the process that causes me in my capacity as a hearing officer to say, well, they did this, and that causes a ultimate problem with whether the order show cause, whether the whole process should continue. So I want you to think a little bit about that. I'm not asking for an answer about that right now, if you understand what I'm raising. But there are a whole host of matters that have been raised by the respondent that appear to me, beyond which some of them may implicate issues of credibility of particular witnesses and the like. That's one thing, but they're broader issues, I would say, and collateral issues that are raised in here. And the vehicle by which they are addressed is something that I want you folks to think about. And we can certainly resolve it or address it, I should say, at the next status conference. So you'll have plenty of time to think about that. And if you think it would be helpful to submit something in writing that states your position about how those ought to be dealt with, I mean, it may be that the division's position is we don't deal with them at all, that they have nothing to do with the ultimate resolution of this case. Obviously, the respondent's position would be different than that. So just think about that and have in mind that we will address it at the status conference, and that if you want to submit something in writing before then, that would be probably useful to me. So.
Understood, Your Honor. Thank you, Your Honor.
All right.
Judge Fishman,
Yes.
sorry, just if the parties do decide to submit anything in writing on that, is there a time and date that you would like to receive anything by?
Tomorrow at 4 o'clock. I want to see all of that, which is if really, I would be happy with any kind of submission on that. Let's say 10 days before the status conference would be, if we can sort of peg that with a date, Lizzie, that would be useful.
Yes, I'm just looking now. So it looks like that would be Wednesday, June 11th.
Your Honor, actually, can I just ask, can I ask that it be 20 days?
Yes.
Because I would like a chance to respond, and
That's-
I will also be out of the country during those 10 days. So
Okay, but-
I'll need the time.
Well, I will too. So maybe we could talk in whatever remote part of the world we're in and get this done. That's fine. That's a good idea. Let's do it. So do it by the beginning of June. Whatever that is, just grab a date for that. Lizzie, I'll leave it up to you there. How about by June 2nd? Does that work?
That's fine, Your Honor.
Okay. There was also, I think, something raised, and I just want to ask you about it because I'll want to be making arrangements for that if necessary. Did I understand that there was a request for one or more witnesses, the potential for needing an interpreter, Mr. Jacobs? Did you say that?
Yes, Your Honor. The mayor, I know for one, he speaks some English. I have had him at a hearing before, but he probably needs to have someone in from a legal process to be able to be present to provide Spanish interpretation if he's called.
Okay.
I mean, I know he would be called by us as a witness. I believe he's on Mr. Hartnett's list as well, but he does not feel totally comfortable in legal issues in being questioned without someone available to translate into Spanish for him. And at the last hearing, we did have that available to him. Simple, straightforward questions, English questions, he can often respond to. But when you're asking more complicated ones that have legal issues, the choice of words, he may not be familiar with the words in the English language where he might be in Spanish. So in order to make any testimony that he would provide, definitely he as a witness would need to have an interpreter, to be fair to him.
All right. That's good to know. That's the only one you have in mind right now.
That is the only one that I'm aware of who is not also fluent in English. There, some of those individuals may be bilingual, but they are certainly, I believe, fluent in English. But Mr. Castro and I will go over that list and make sure that that's our assumption.
Okay.
But I know Mayor DePina, based on the last hearing that I did where he was called in as a witness, needs the assistance of an interpreter.
Gotcha. Okay. Any other issues from the respondent's point of view that we need to address today?
No, Your Honor. Thank you, Your Honor.
And from the division's point of view?
No, Your Honor.
All right. Well, thank you all. Look forward to your submissions, and we'll see each other on the June 23rd.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Thank you.